So picture this. Your parents worked their entire lives, saved diligently, paid off their mortgage, and when they passed away, they left you the family home worth about $400,000. You think great, at least something good came out of this tragedy. Fast forward 6 months, and you get a letter from the state government saying they want $230,000 back. You are sitting there thinking, what are they talking about? I paid the estate taxes. I filed everything correctly. But here is the thing, this is not about estate taxes. This is about something called Medicaid Estate Recovery, and it is one of the most quietly devastating wealth transfer mechanisms that exists in America today. My name is Leo, and I spend way too much time thinking about how the government has built in systems to reclaim wealth from middle-class families who think they did everything right. If you are someone who assumes that just because your parents' estate is under the estate tax threshold you are safe, make sure to hit the subscribe button and give this video a thumbs up if this helps you out. Because here is what most people do not realize. Every single year, state governments recover over $1.2 billion from deceased individuals' estates through Medicaid clawback provisions. And that number is growing exponentially as more baby boomers enter retirement and eventually need long-term care. Look, here is how this actually works, and why it catches so many families completely off guard. When your parents or grandparents need long-term care, whether that is a nursing home, assisted living, or in-home care, the costs are absolutely astronomical. We are talking about $8,000 to $10,000 per month on average. Let me give you the actual math here. The average nursing home stay in America right now costs about $8,500 per month. The average length of stay is about 3 years. So you are looking at over $300,000 in costs. Now, Medicare, which is what most people think covers everything, only covers the first 100 days, and even then, only partially. So families are left with basically two options. Either you pay out of pocket, which would completely drain most middle-class families' savings in less than 3 years, or you qualify for Medicaid. And this is where people think they have found the solution. Medicaid will cover long-term care costs, but here is the part that nobody tells you upfront, or at least not in clear language. When you sign up for Medicaid to cover those costs, you are essentially taking out a loan from the government, and that loan comes due when the Medicaid recipient dies. This is called the Medicaid Estate Recovery Program, or MERP, and it is authorized under federal law, but administered by each individual state, which means the rules vary wildly depending on where you live, but the core concept is the same everywhere. The state has the right to recover everything they paid out for your care from your estate after you die. Now, you might be thinking, okay, but that only applies to people who have nothing, right? Wrong. This is where it gets really interesting. The income limits to qualify for Medicaid are actually pretty low. In most states, you cannot have more than $2,000 in countable assets. But here is the kicker, your primary residence is usually not counted as an asset when determining eligibility. So what happens is, families will spend down their liquid assets, their savings accounts, their investment accounts, to get below that $2,000 threshold. But they keep the house because it is exempt. They think great, at least we protected the family home. Mom or dad can live there, and when they eventually need care and go on Medicaid, the house will pass to the kids. Except that is not how it works, because while the house does not count against you for eligibility purposes, it absolutely counts for estate recovery purposes. After the Medicaid recipient dies, the state files a claim against the estate, and that house you thought was safe, the state wants their money back out of it. Let me give you a real example with actual numbers. Say your mom owns a home worth $400,000. She needs nursing home care for years before she passes away. Medicaid pays out about $180,000 for that care. When she dies, the state files a lien against the estate for that $180,000. Now you, as the heir, inherit a house worth $400,000 with a $180,000 lien on it. You have basically 3 choices. You can pay off the lien in cash if you have it, which most people do not. You can sell the house and pay off the lien from the proceeds, which means you just lost nearly half the inheritance. Or you can try to negotiate with the state, which is incredibly difficult and rarely successful. And here is where the psychology gets really dark. Most families do not even know this is coming until after the loved one has passed away. They are grieving, they are dealing with funeral arrangements, they are trying to sort through decades of belongings, and then they get hit with this massive bill. The numbers are staggering. In 2000, states recovered about $200 million through estate recovery. By 2024, that number had grown to over $1.2 billion. And it is projected to keep climbing as more boomers age into Medicaid eligibility. Now, here is what makes this even more complicated. Every state has different rules about how aggressively they pursue recovery. Some states only go after people who were over 55 when they received benefits. Some states try to recover from everything. Some states have hardship exemptions. Some barely pursue recovery at all. For example, Florida is one of the most aggressive states for estate recovery. They recovered over $100 million in just 1 year. California, despite being much larger, actually has more protections in place and recovers significantly less per capita. Texas falls somewhere in the middle. So what can you actually do about this? Because here is the thing. I am not just going to tell you about the problem without giving you solutions. And there are legitimate legal strategies to protect assets, but you have to do them correctly and you have to do them early. The first and most important thing to understand is the 5-year look-back period. Medicaid looks back at every financial transaction you made for the 5 years before you apply. If you gave away assets or sold them for less than fair market value during that time, you could be hit with a penalty period where you are ineligible for benefits. This means if your parents are 70 years old and healthy, but you are thinking ahead, now is actually the time to start planning. Not when they are 85 and already need care. Because once you are in crisis mode, your options become very limited. Strategy number 1 is an irrevocable trust. Now, I know what you are thinking. Trusts sound complicated and expensive. And yes, they do require upfront costs and they do require you to give up control. But here is why they work. Once you transfer the house into an irrevocable trust, it is no longer part of your estate. The key word there is irrevocable. You cannot take it back. You cannot change your mind. But because it is not in your name anymore, Medicaid cannot count it as an asset. And they cannot recover from it after you die. As long as you do this more than 5 years before applying for Medicaid, you are in the clear. Strategy number 2 is called a life estate deed. This is where you transfer ownership of your house to your children, but you retain the right to live there for the rest of your life. Again, this removes the house from your estate for Medicaid purposes, as long as you do it more than 5 years before needing care. But here is the catch with life estate deeds. Once you do this, your kids technically own the house, which means if they get sued, go through a divorce, or have creditor problems, the house could be at risk. So you are trading one risk for another. You have to really trust your children and their financial stability. Strategy number 3, and this is the one most people should have considered 20 years ago, but it is what it is long-term care insurance. If you are in your 50s or early 60s and still healthy, this can be a viable option. The premiums are high, usually $1,500 to $3,000 per year, but that is way less than risking your entire estate. Now, here is my honest take on long-term care insurance. The policies are expensive, the companies can raise premiums over time, and a lot of policies have strict limitations on what they will actually pay for. But if the alternative is losing your house to Medicaid recovery, it starts to make more sense. Strategy number 4 is to actually research your specific state's rules. Because, as I mentioned, they vary wildly. Some states have undue hardship waivers. Some states have exemptions if a child lived in the home and provided care for at least 2 years. Some states will not pursue recovery if it would make a surviving spouse homeless. Strategy number 5, and this is non-negotiable, is to consult with an actual elder law attorney in your state, not a general estate planning attorney. You need someone who specializes specifically in Medicaid planning. These rules are so complex and change so frequently that you absolutely need expert guidance. Now, here is something really important that people miss. There are specific exemptions that can protect your estate even after you have gone on Medicaid. One of the big ones is if you have a child who lived in the home for at least 2 years before you went into a nursing home and provided care that delayed your need for nursing home care. This is called the Caretaker child exemption, and it can completely protect the home from estate recovery. But you have to document everything. You need to show that the child actually lived there, that they actually provided care, and that the care actually delayed the need for institutional care. This is not something you can fake after the fact. Another exemption exists if you have a disabled or blind child living in the home. In that case, many states will not pursue recovery because it would make the disabled child homeless. But again, this has to be properly documented and the child has to meet the legal definition of disabled, which is pretty strict. There is also something called the surviving spouse exemption. As long as a spouse is still alive, states will not pursue recovery. The lien just sits there until the surviving spouse also passes away. The problem is, many people do not realize this means the surviving spouse cannot sell the house or refinance it without dealing with the lien. So picture this. Your dad goes into a nursing home, goes on Medicaid, and then passes away. Your mom is still alive and living in the family home. The state files a lien but does not enforce it yet. Your mom lives there for another 10 years. When she dies, now the state comes after the estate for both your dad's care and potentially your mom's if she also needed Medicaid. The lien just keeps growing. And if the surviving spouse also ends up needing Medicaid, well, now you have got two liens stacking up. This is how a $400,000 house ends up with $300,000 in liens against it. Now, there are more advanced strategies like Medicaid-compliant annuities, but these are incredibly complex and have very specific rules. Basically, you convert assets into an income stream that does not count against you. But mess this up, and you have just given away your money for nothing and still do not qualify. There is also something called the spend-down strategy, where you strategically spend assets on exempt items before applying for Medicaid. Things like paying off debts, making home improvements, buying a more reliable car, prepaying funeral expenses. These are all allowed and can preserve value while still qualifying. But here is what nobody wants to talk about. All of these strategies require planning ahead. They require uncomfortable conversations with your parents about aging and death and money. They require spending money upfront on attorneys and possibly insurance. And most people just do not want to deal with it. I get it. It is awkward to sit down with your 70-year-old parents and say, "Hey, we need to talk about what happens when you need long-term care." It feels morbid. It feels like you are planning for their death. But the alternative is so much worse. The alternative is being completely blindsided by a six-figure bill when you are grieving. The alternative is losing your childhood home because nobody knew about estate recovery. The alternative is family fights about who should have done what, all while the state is knocking on the door with their hand out. And look, the statistics are clear. About 68% of people over 65 will need some form of long-term care. The average length of care needed is about 3 years. The average cost is over $250,000. This is not some rare edge case. This is the default outcome for most American families. And here is the really insidious part. This system is specifically designed to target the middle class. If you are wealthy, you can afford to pay for care out of pocket and preserve your estate. If you are poor, you never had assets to lose anyway. But if you are middle class, you are right in that sweet spot where you have just enough for the state to recover, but not enough to avoid Medicaid. You spent your whole life building up that nest egg. You paid off your house. You saved for retirement. You did everything right. And then one medical crisis, one need for long-term care, and it all gets clawed back. Not because you did anything wrong, but because the system is literally designed to recapture that wealth. Now, are there ways to fight this after the fact? Sometimes. Some states have hardship waivers if recovering would cause undue hardship to the heirs, but the bar is incredibly high. You basically have to prove that losing the estate would make you homeless or unable to meet basic needs. Some people try to appeal or negotiate with the state, and occasionally they succeed in reducing the amount owed or getting better payment terms. But this requires hiring attorneys, which costs money, and fighting the government, which takes time and energy when you are already dealing with loss. This is why I keep coming back to the same point. The time to deal with this is now. Not when you are in crisis. Not when your parent is already in the nursing home. Not when you are reading the estate recovery letter. Now, while everyone is healthy and you can plan properly. So here is what you actually need to do. Step 1. Have the conversation with your parents or with your adult children if you are the older generation. It is uncomfortable, but it is necessary. Step 2. Research your state's specific Medicaid estate recovery rules. Every state is different. Step 3. Consult with an elder law attorney who specializes in Medicaid planning in your state. Not next year. This year, get actual professional advice based on your specific situation. Step 4. If you are going to do asset protection, do it now. Do not wait until you are 85. The 5-year look-back clock starts ticking from the moment you take action. Step 5. Document everything. If you are providing care for a parent, document it. If you are living in their home as a caretaker, document it. If you are making financial decisions, document it. All of this can matter later when dealing with exemptions or appeals. Step 6. Review and update your plan regularly. Laws change. Family situations change. What made sense 5 years ago might not make sense now. This is not a set it and forget it thing. This requires ongoing attention. Look, I know this is not the fun financial content. It is not about getting rich or finding the next great investment. But protecting what you have is just as important as building wealth. And if you can save your family from losing half their inheritance to a system they did not even know existed, that is worth way more than any investment return. The goal here is not to cheat the system or avoid paying legitimate debts. If Medicaid provides care, they do deserve to be reimbursed. But the goal is to use every legal tool available to protect your family's wealth and to make informed decisions rather than being blindsided by rules you did not know existed. Because here is the bigger picture. Every generation is supposed to build on what the previous generation built. That is how families build wealth over time. But if every generation gets hit with these estate recovery clause, that generational wealth building becomes almost impossible for middle-class families. The wealthy protect their assets through trusts and sophisticated planning. The poor never had assets to protect, but the middle class keeps getting squeezed, and mechanisms like Medicaid Estate Recovery are a huge part of why wealth inequality keeps growing in this country. So here is my challenge to you. This week, have the conversation. I do not care if it is awkward. I do not care if your parents say they do not want to talk about it. You have to have the conversation, because if you do not, you are gambling with potentially hundreds of thousands of dollars and your family's financial future. If this video helped you understand something you did not know before, or if it is going to save you or your family from a financial disaster down the road, hit that subscribe button and give this video a thumbs up. Share it with someone who needs to see it, because this information is too important to keep to yourself. My name is Leo, and I will see you in the next video where we will talk about more ways to protect your wealth from systems designed to take it away. Thanks for watching.